Okay, we are on the record in the matter of Gatehouse Media versus CR Motors. Counsel, state your appearances, please.
Ron Marienfeld on behalf of the defendants.
Michelle Harrell on behalf of plaintiffs.
Hey, good afternoon. So this is defendant's motion for summary disposition.
Yes, Your Honor. I know the court. Go ahead.
I have read your briefs.
And that's what I was just going to say. I know the courts went through it all, and you know the standard here. I'm not going to rehash everything, but I just want to point out a couple issues, and I really think the court can focus on two questions. Number one, what did Hawkins do that was a violation or was a breach? It was at-will employment. She left her job. She had every right to do that. She had legitimate job concerns that had nothing to do with the CR defendants. With the merger and the layoffs, the testimony was covered by all the witnesses. Took a job with a company not in competition with her and had been looking for other jobs, was the testimony. Didn't solicit or divert or try to interfere with CR. The only real argument is that she somehow took this proprietary material. Well, the material, and we laid it out, I hate to keep going over it, but was provided by the strategic team manager. And this was back in June, before she had left the company. She's still working for them and trying to improve the account, save the account really. And there's actually a process.
But the information wasn't provided to the other defendants except by her, correct?
Correct.
So when the information was given to her, she was still an employee of the plaintiff who was entitled to the information as an employee, since it related to her duties on behalf of this group of clients. So I fail to see how the distinction you're trying to make matters. The concern isn't the disclosure within the company to another employee. The concern is with the disclosure outside the company. And that's my understanding as to what the plaintiffs are complaining about.
Correct, Your Honor. And she stated to her strategic team manager that the third party, in this case, the CR parties, were asking for the information and wanted to see it. His response was, yeah, here it is 2 days later. And actually, I'd like to meet to talk about it. So he provided that information. There's actually attached to the plaintiff's brief is the contract that they have language. There's a process to object, to state that the information is confidential. But he knows this. He's the account manager. He knows what information would be confidential or not. And she didn't try to hide anything. She stated in writing, this is who it's going to, and this is why they want it. And he provided it. Now, the argument is she did this behind the back of her boss who was off duty, but the testimony showed they had access to the same information. Both would have asked O'Brien, and O'Brien would have provided it or not. If it was proprietary or confidential, he wouldn't have provided it. So that's why I'm showing the distinction. She was doing her job at that time, taking the information that the customer's asking for and providing it to them to try to save this account.
Well, isn't the theory that plaintiff has is that she was in the very process of leaving her employment, going to work for the other defendant companies, where she would be doing for them exactly what the plaintiff is doing for them while she's employed by them.
That may be the theory, but it's not what the evidence showed out. The evidence from Hawkins and the others, Rome Moreno, where that she does various things for them with the car dealerships, with warranties. She's not just selling she's not selling digital marketing campaigns like the plaintiffs did. She was looking
No,
for.
no, not selling them, conducting them for the defendant companies, just as the plaintiff did when she worked for plaintiff. So let me just back up a minute. My understanding is that the plaintiff provides these under its contract, provided these advertising services for the defendant companies. I mean, is that accurate?
Yes.
All right. And the main account representative for plaintiff, when those services were being conducted for the defendant companies, was this employee. And I'm sorry, I lost the name.
Hawkins.
Hawkins, yes. Is that true?
Yes.
And now she's doing that very same thing, except not as a private company, but rather as an employee. In other words, they brought all this work in-house and they're using her to perform, they may not be identical, but similar advertising services to advertise their businesses.
The testimony from Hawkins is that she was asked occasionally by Sam Jones to see how their marketing was doing, basically to check the Google Analytics. That's what she testified to. Not that she's doing that. She answers phones. She deals with the dealership side, there's various entities. So she's not selling anything or providing just digital marketing campaign management.
Well, the fact that she's doing other work while she's there, I'm not sure has any bearing on this. The real issue is she in fact doing in-house or assisting them to do in-house what she previously did on behalf of the plaintiff companies?
There may be some overlap that she can look at the Google Analytics, like per her testimony, and like really anyone can. Me, you, the defendants, or the plaintiffs. That's why the claim that it's proprietary information when everybody can get it. There was a reason O'Brien didn't hesitate in providing the information. Is one, the defendants provided most of it in the first place from their MLive contract before Gatehouse. And everybody, the testimony from Hawkins is that everybody can get to this information. Even Chapin, the former employee, testified to the same thing. So this isn't some secret information, and there was a big conspiracy to steal this information. The plan was plummeting. Their sales were going down. There wasn't any motivation to steal the policy or steal the information. And
so why, if the defendant companies are unhappy with the way the plaintiff was conducting their ad campaign or whatever it's called, why would they hire the very person from the plaintiff who was primarily responsible for handling their account? That doesn't make sense.
well,
It doesn't make any sense that you're unhappy with the services, so you hire the very key employee who's handling those services and you put him to work for yourself. I have trouble making sense out of that.
The testimony that came out is that she was trying to help them all along, and it wasn't her that was making the plan. This was the strategic team, because this was a big account. This isn't the Gatehouse in-house that they were working with before. This went to the strategic team where Dan O'Brien is. And Hawkins spent most of the time from the beginning of the campaign trying to fix it, and they knew that. And the testimony that came out was from everyone, and I don't think anybody disputes she approached them. This wasn't that they had some idea that, look, we're going to steal her and steal the secret sauce. She came up to them and said, look, things don't look like they're going good. Do you have a place for me? So, and she asked for a sales position. They sell cars and warranties. Again, she's not selling digital marketing campaigns. So that was the reason. I mean, they tried to help her out, and she took a pay cut, quite a pay cut to go there. But she wanted flexibility and wanted out of there. I mean, it's not, again, it's the defendants definitely believe that this is some sort of a conspiracy and this was a grand plan, I think, from the beginning. But it just doesn't make sense, and there isn't the evidence to support it. I mean, she was an at-will employee going to a non-competing company. And again, she doesn't have a non-compete anyway, but they don't even do the same thing. And
So I wasn't under the impression that she's being sued for violating a covenant not to compete.
no, she's not. But I'm just pointing out the motivation for what, why she doesn't have anything to gain. She's not benefiting, or nobody's benefiting from this, whatever the proprietary material was. It's not like she took it and sold it to other people or is soliciting other customers. She went and got another job. And this information passed before that while she's doing her job, as part of her job.
But didn't it pass like days before she left?
It was, I think, a couple weeks. Not this whole thing didn't last too long.
When she already knew she was going to be going to work for them, and when they already knew she was going to be going to work for them. Is that correct?
The documents show that this happened afterwards, that she, in July 2nd, she started talking with her boss about leaving. That's what the attached documents show. And it wasn't like she had been talking for over a month with her boss about this. So again, the conspiracy just isn't there. Did she put it in writing?
She was talking to her boss at the plaintiff companies that she was getting ready to leave?
Yes. From the beginning.
Did she tell her boss that she was getting ready to go to work for one of the customers?
I think there may be a dispute on that issue. I'm not positive, to be real honest. But she talked about it, and actually her boss tried to help her tweak her resignation letter and when to set it in, or it probably would have went out sooner, but she had her staying on and was trying to convince her to stay. So this wasn't hidden. This wasn't a surprise. It was over about a month they were talking about this back and forth. That's what the text messages show.
So going back to where you started out, maintaining that she was an at-will employee, she didn't breach any contract when she terminated her employment and went to work for the customer. I wasn't under the impression that plaintiff was arguing that she breached a contract by terminating her employment. I was under the impression that the argument is she breached the provisions within her contract of employment when she diverted confidential information to the customer and when she solicited for herself employment with that company. So it wasn't the termination of her employment that's the breach. It's what she did that is the breach.
I think that's their claim. I think the solicitation part is from soliciting other employees to go work, though. The claim was to interfere or solicit or divert business as far as the CR defendants go. And again, yes, I would agree with that. And there hasn't been any evidence brought to show that anything she did caused them to leave their business. They gave her a job. That was all they did. And again, I don't see what she did was a violation of that agreement. When she worked for the company, the customer asked for the information. She still worked there. She hadn't left, even given her resignation, hadn't even talked to her boss about it yet, and gave the information telling the people above her who it was for and why they wanted it. He gave it to him. He gave it to her knowing where it was going. So that's why, again, I don't see where her violation of that agreement comes in at all, or what she did. Again, I'll continue with Hawkins, but I was going to cover the same point on CR, just as far as what they did to cause, one, Hawkins to leave her employment when she asked them to leave, or she asked them for a job, I'm sorry. They didn't have knowledge of any agreement, any employment agreement that she had. There's been no evidence submitted of that they knew about this at all. And they had the information beforehand, before they even hired her. They used the 30-day opt-out. Now there's, I don't know how it can be argued. There is a 30-day opt-out. They can argue that whether it was for cause or not, but the emails going back to April show Sam Jones wasn't happy. And this Hawkins even testified he had been using these different vendors doing different things all the time. And he picked the 30-day opt-out contract for a reason.
Well, let's take a look at that contract language since we're on that subject. I think this was Exhibit G. Am I remembering that? No, that's not right. I'm sorry. I'm confused about which stack of exhibits. So yes, it was Exhibit G to the plaintiff's response. So we're looking at the same thing. And the provision about a 30-day notice of termination. I should have highlighted it. Counsel, if you can help me find that right page.
I've got it as Exhibit I, Your Honor. Is what I believe you're referring to of our brief.
Yeah, I don't care which one. I don't care which one. I just want to find the what you're referring to as the opt-out provision.
It's the Exhibit I, first page of the defendant's brief.
Okay, I'm looking at your Exhibit I. Oh, okay. I was looking for it within the agreement. You pulled it out and printed it separately.
Right. And that talks about the either party may terminate on 30 days written or email notice. And again, this wasn't
if the other party is in material breach of its obligations under the order, and such breach has not been substantially cured by the end of the termination notice period. I get that your clients say they didn't think they were getting their bang for their buck, but isn't that a question of fact as to whether or not the plaintiff was in material breach of its obligations? This isn't an opt-out provision. This isn't a termination for convenience provision. This is termination for cause. So in order to take advantage of this, they got to prove that there was a material breach, and I guess more importantly, that they even gave them an opportunity to cure this alleged material breach. What was the alleged material breach?
Not only that it wasn't performing, that they had put them on notice of it since the beginning of April, but also that they had asked for the spend figures and weren't provided those. And then when they were provided them, we showed that the money wasn't being spent per month like it was supposed to be. And that's what they asked for, is the transparency that they didn't get, that they thought was a material breach. And again, the evidence shows this wasn't a surprise. They had been complaining since April, and Sam Jones told them, if I If it doesn't get fixed, the testimony was, I'm canceling in July, and they did.
So where's the cancellation notice? Which exhibit is that?
I think, bear with me one second, Your Honor.
I think it might be J, Mr. Marienfeld, to your motion. It says cancel notice in your brief.
I believe that is correct. Thank you.
Right? Yeah, so much paper.
All right, give me a moment. So I look, if this is the notice of cancellation, and I compare that with the language from the termination for cause excerpt that's in your Exhibit I don't see that there was even a proper notice of termination, even if there was cause. It says, notice must be received on the Thrive Hive cancellation form. It shows where that can be accessed. It says in bold letters, no other means of termination by advertiser will be valid. So somewhere in these exhibits, is there a copy of this cancellation notice form?
I don't see those in, Your Honor, and that's kind of what we pointed out. They talk about the form in there, and then they also put right in the second sentence that it's prior written or email notice. So I believe there was actually a prior one. I'm not getting my hands on it right now. That was sent back in July. That's what the testimony was. I believe this one was the final one.
It looks like it's something that's available online. Let me see if I can find it. Lo and behold, here it is. Cancellation notice. Even says how to do it. If you wish to cancel your Thrive Hive products, please see the below options. And here's the request for cancellation form. Let me see if I can open that up. So, Mr. Marienfeld, there's no dispute. Your client did not use that form to try to terminate this contract. Is that correct?
I don't know if that is correct, Your Honor. I'll let plaintiffs speak to that exactly. We do still have discovery, so I can confirm that, but I believe there was discussion of that early on, and as we said here, I don't have the notice with me, or the cancellation notice. But they did provide prior written and email notice, as it states in the second sentence.
Was there any opportunity given for the plaintiff to cure whatever it was that your client claims they were in material breach of?
The documents show since April 22nd, there was communications regarding that, and it was never cured. The documents show that the curing may have been that instead of holding back the money, once they knew the plaintiffs or the defendants were leaving, all the money was spent in August.
Your Honor, I'd like to answer some of those questions, but I don't want to interrupt Mr. Marienfeld.
And I'll give you that chance, counsel.
I know, I don't want it.
All right, you may continue with your argument, Mr. Marienfeld.
Right, and I'll just wrap up, Your Honor. I kind of think I know where we're heading, but I think you stand back and look at it, what we have is, and we've seen from the preliminary injunction, this lawsuit was simply a way to try to strong arm the defendants to coming back and doing business with the plaintiffs. That didn't work. So the bottom line is we're gonna started off 13 counts, I think, whittled it down to 9 to throw out the kitchen sink to see how much money we can make them spend. And that's the only reason we're here today. So if it needs to go to a jury, then it can go to a jury. But I think if you look at what the parties did, it's nothing but they're upset that they won't do business with them anymore, and they were a big account. And they didn't pull the rug out from them. They'd been dealing with this from the beginning. 1 week into the campaign, they were complaining. So to say it's a surprise, I think is disingenuous. We'd ask that you grant the motion, but I'll defer to counsel.
Ms. Harrell?
Yes, Your Honor, thank you. Mr. Marienfeld's correct that this small paper, the Daily Telegram, this was their largest customer, and this was devastating for this newspaper. And we're going to present to the court what happened to this newspaper because they lost their largest account, no question. But the reason this case was filed was to stop them from using our marketing campaign and to enforce our agreement against Ms. Hawkins. So the court, I think, has read through all of these papers, and we appreciate, Your Honor, this is a lot of paperwork. And I was swimming in it myself. But Your Honor, you're right about the timeline, which is really important here because it's very, very tight. And it coincides with Ms. Hawkins' design to leave Gatehouse and to go work for the defendants. So she actually emailed that she had accepted a job offer on July 29, 2019. And the defendants had never used the form, which is, it's clear that they had to use the form to cancel the contract. And the reason is because Gatehouse wants to know if someone's canceling a contract, that then they have 30 days to make it right. So they want to know why, and they want the form to go by the right channel. But what these defendants did, and this is indicative of their overall plan, Sam Jones, who is the owner of CR Motor, he sent an email to Hawkins, this employee, and he emailed only her on the same day to say, we are canceling our contract under our 30-day opt-out. And she sent that to no one else. They had already knew she was leaving. And this is just the tip of the iceberg is what they had been doing for a couple of months. So what we've shown through our submissions is that they want to say she was leaving because it was a bad place to work and she had family and we were terrible. That's their story to tell. But what we have shown through the timeline, through the documents and the testimony, is that she worked at Gatehouse taking a paycheck while she was doing work for defendants on the side. There are emails in the record that show she was being copied on defendants' vendors' marketing companies to her personal email. And by mistake, sometimes they would copy her gatehouse email. So we saw those emails. So she was working on this campaign of hers while she was still on our employ. And at the time, Mr. Marienfeld, I'm assuming he's not purposely misrepresenting the record, but the record shows that she failed to disclose and in fact eventually concealed who she was going to work for from her manager, who is Jamie Chapin, because she said she didn't want her new boss to meet her old boss. And that's a quote. So we did not know that she was going to work for our biggest customer this whole time, because that would have been eye-opening and she probably would have been fired. But that didn't happen. So she was still there doing all this inside work. So when her manager went out on medical leave, she decided this was her chance to get the marketing campaign. Now, defendants want to say we're trying to sue them over keywords. That's ridiculous. You and I can go on Google and say car warranty, car dealership. We're not suing them over keywords. We are suing them over the marketing plan, which is part of Excel spreadsheets that were produced. And they are part of the case that shows the entire marketing campaign that we had planned for these defendants. So while she was a covert agent, she asked this employee who did not know that she had taken a job offer or was planning to leave, and he gave it to her. And she took that and gave it to the defendants. Now her email request to him says, I'm trying to work on their campaign. I just want to see what it's about so I can fix it. She didn't say, hey, send it to me. I'm passing it on to the defendants. And this employee who is still at the company
Can I see that particular email? Which exhibit is that?
Let me see. I can find it here. I'm sorry. Bear with me, Your Honor. I'm trying to find in all these.
Just to help, it's F in my brief.
Is it F in yours? Okay, Ron. Thank you, Ron.
So from Nicole Hawkins to
Daniel O'Brien.
Daniel O'Brien. Can you give me a list of all keywords we are bidding on and a copy of all our ad copy? The client is asking for it to see where we can add better call to actions. Well, that certainly sounds like it's the client's request that she's passing on. How?
Well, the testimony, Your Honor, is that she said that she wanted this information because the client was asking her to take a look at it and fix their campaign, which is what Mr. Marienfeld talked about, was that they were not seeing the results they wanted from this campaign. So they were leaning on her as their marketing person to make it right. So the testimony about that document is different for both sides. We're both trying to indicate what it means.
But in any event, your argument is the keywords is a red herring. It's the whole advertising campaign that she was able to basically hijack by becoming their employee.
Right, that she took that with her and they have that and they're executing on that, or at least the parts that they want. So the other issue is that we already talked about the cancellation of the contract, that Sam Jones, had sent that cancellation only to her it was clear and obvious that if he really wanted to cancel, he had to do it by the form, and certainly not send it to the person that he was hiring away from us. What's interesting too is that before Hawkins left Gatehouse, we found in her documents, in her emails, even though she deleted all of her emails back and forth between her and defendants, so we couldn't even see what she had been talking about with them as their account manager, but she deleted all of them. But what we found in her drafts was that she had went in and drafted the email from the defendant, supposedly, revoking Gatehouse's access to Google Analytics, which to us, is a clear conflict of interest and a breach of her fiduciary duty, that she would be drafting this document as if she were the CR defendants to Google saying, cut off their Google Analytics access, which to me says it all, really, that this is what her plan was. And before she left, she made sure she locked the door on her way out. So I won't go through a lot of this I know it's all in the briefs. The concept of whether the Gatehouse marketing program was successful or not, that's going to be a huge question of fact, and whether there was cause to terminate this contract. These are marketing contracts. If you sell less cars, you're going to sell less warranties. If you have bad salespeople, you're going to sell less cars. Like, there's so many factors here that there's too many questions of fact. So, Your Honor, if you have any questions for me, I'm happy to answer them, but I know you read all these briefs, and there's 600 plus pages of exhibits, which is, to me, screams questions of fact.
All right. Well, I believe that there indeed are some unresolved and disputed material questions of fact that would preclude me from granting summary disposition as to all of the counts, but I do want to speak to each of the counts. So give me just a moment. Let's see where they're laid out. The one in particular that came to mind, because you just triggered my memory of it, I don't believe there's a valid claim here for breach of fiduciary responsibilities. She was not in the role of a fiduciary. She certainly has obligations under her contract with respect to misuse of confidential information, for which she can be held accountable under the breach of contract claim, but she's not in the position of a fiduciary. So I am going to grant summary disposition as to the count that asserts a claim for breach of fiduciary responsibility. So we can at least make that one go away. Let me look back through. Right, that was breach of common law fiduciary duties by Hawkins.
Count 6, Your Honor.
Count 6.
Yeah.
Your Honor, one other thing I just wanted to point out, and that's definitely give Michelle a chance to respond to this. I don't think there has been anything produced. I don't know if there's a dispute over this, that CR Motor Sales Inc. and Tim Zacharias didn't sign any contracts. I don't think they were involved in anything was submitted with their name on it. So I would put that out there. I'm not sure they should be in this case.
Response, Ms. Harrell?
The only thing I was going to say is the CR Motors of Adrian is definitely a distinct entity. There's two separate, and I just wanted to note that.
Right. Well, we think that they are within the conspiracy claim and also the trade secrets claim. They're all interrelated entities. I mean, we have taken discovery, and their organizational structure is actually unclear to us at this point. We've had some issues in discovery trying to uncover how they're related and what they're actually doing in between each other. So,
was Gatehouse providing any of its contract media services to the entities that Mr. Marienfeld just identified?
Yes, Your Honor, they were included in the ads. So they were within the scope of the contracts as far as we assert.
I don't believe that's accurate. I mean, I guess we could submit additional documentation.
Is there a claim made that Hawkins breached her employment contract simply by leaving her employment with the plaintiffs? You're
No.
not alleging that that's a breach, are you?
No, Your Honor. We believe
Okay.
he was an at-will employee, so.
All right. All right, there definitely is a dispute of fact as to the breach of contract claim against CR Motors. Clearly, that contract allowed for termination for cause. So whether or not cause existed and whether it was sufficient and whether there was a sufficient opportunity to cure and whether proper notice was given are all questions of fact that would preclude me ruling on that claim. I do agree that the allegation for breach of an implied covenant of good faith and fair dealing is a count that should be dismissed. Trade secrets claim, there's questions of fact there. Tortious interference with a business relationship by Hawkins, questions of fact. Tortious interference with contract of CR Motors. That claim is that, what's your theory with that claim, Ms. Harrell?
That's the claim that they came in and interfered with our contract and our relationship with Ms. Hawkins, that they hired her away from us. So that's an
interference with a business relationship, not an since the allegation is not that they induced her to breach her contract in that regard. It's simply that they interfered with the ongoing business relationship by offering her a job and luring her away.
Right, but they interfered with that.
Well, I'm not very impressed with that claim, but I think there are questions of fact that would preclude me from granting summary disposition. I've already spoken to the breach of common law fiduciary duties. I don't believe there's support for that claim. And as to the conversion, I am very, very skeptical that you can make a conversion claim under the facts of this case, but I am not prepared today to dismiss that claim, but I'm very skeptical of it. Unjust enrichment, that can be dismissed. That's a theory to recover when there isn't a contract. You've got a contract. You can't recover on a breach of contract and also recover on a claim of unjust enrichment. I realize that alternative pleading allows inconsistent claims, but here there clearly is a contract. You either have a remedy under that contract or you do not. You can't, unless the whole contract is vitiated, make out a claim for unjust enrichment. So I'm going to dismiss that claim as well. Inducement to breach fiduciary duty. Similarly, if she didn't have a fiduciary duty, she couldn't be induced to breach it. So I'm going to grant summary disposition as to that claim. Civil conspiracy. What's the criminal or unlawful purpose or unlawful means that is underlying this theory, Ms. Harrell?
The conspiracy claim is based upon the fraudulent conduct of Ms. Hawkins, we believe assisted by CR Motors, to take our trade secret information, and how they were all acting together in a conspiracy, combined together to make that happen. So it's basically.
All right, well, I think there are questions of fact on that then. I'm not sure this faithless servant claim I don't think that applies under the facts of this case, and I'm going to grant summary disposition as to that count. So we've at least cleaned some of this up. Clearly, what remains, unless the parties are able to reach a resolution, is something that's ultimately going to have to be decided by the trier of fact. I don't know realistically how soon I'm actually going to be conducting a jury trial. I think it's a ways away yet. Probably sometime this fall, I'll actually be able to have a jury in my courtroom and be able to take them back and forth to the deliberation room. The mechanisms that are being developed for doing jury trials don't impress me so far. I don't see practically how I can do it, other than going to a remote location, which we have one now for the county. But I'm going to be standing in line behind a number of criminal trials. They're only going to be able to do one at a time until we can open back up and have jurors in the building. The only thing that I think I could use the remote facility for is in selecting a jury, so we can keep them somewhat distanced. But the handful, depending on what group size restrictions happen to be in place, to actually conduct the jury trial, I've got to be able to get jurors in and out of my jury room without having to take them off to some remote site or some remote location in the building. I just don't see that happening until things have really pretty much returned to normal. So,
Right.
Mr. Marienfeld, if you would prepare an order consistent with my ruling here today.
I will, Your Honor.
All right. Thank you, counsel. Have a good day.
Well,